Welcome everyone to Google My Business Problems series. We are back today with Erica D'Angelo from D'Angelo Law, and she's going to be talking about the difference between supplemental and principal registrars. I have no idea what this means, so I'm so excited to get to hear this straight from her for you to solve your Google business problems. So Erica, I need you to be telling us what the difference is and what this means for us.
All right, Breck. So there are two types of registers, and when you apply for a trademark, that you can end up getting your trademark registered to. One is supplemental, one is principal. Generally, when you apply for a trademark application, you're trying to get on the principal register. That is the main register and gives you the most amount of protection for your trademark. Sometimes people end up on the supplemental register for reasons like their mark is too descriptive or it's geographical in nature, and there's not enough uniqueness to get on the principal register. Now, the biggest benefit of being on the principal register versus the supplemental register is that on the principal register, you have a presumption of incontestability after you've been using the mark for so many years. This means if it were ever to come up as a dispute on infringement, it would be whoever doesn't have the registered mark's burden to try to disprove or try to prove the infringement exists. But when you're on a supplemental mark, that kind of presumption doesn't exist. So you still have protection like you would under common law rights. The other benefit of being in a supplemental register versus no register, because some people might be thinking, well, if I already have common law rights, why do I need to apply it for the supplemental register at all? The benefit of that is that you can still sue in federal court. So the same types of remedies are available to you that you would have on the principal register if you get on the supplemental register versus no register at all. Another good part about the principal register is that there's constructive notice to everyone. If you're on the principal register and you're using a trademark, the whole world is supposed to already know through constructive notice. So with the supplemental mark, sometimes examiners will offer that as an option when you get an office action. They might say, hey, sorry, your mark is too descriptive, or this is your name, this is your last name, so we're not going to allow you on the principal mark, but you can apply for the supplemental mark, and then we'll go from there.
Okay, so what kind of rights do you have under common law? Because you just mentioned that. So, I mean, are there any rights if you haven't put together a trademark?
There are rights. So people don't have the right to copy and infringe on your works and using your brand name intentionally. But when you don't have a trademark in place, you don't have as many legal tools, remedies, and the same type of burden of proof that is more in your favor when you have a registered trademark versus not having a trademark at all.
Okay, so are the auditor people, the people that are telling you whether you can have the trademark or not, are they just offering you a supplemental because they're kind of lazy and they don't want to do anything else? Because that's kind of what it sounds like to me. Like, hey, if you don't want to go through and do more paperwork, then you could go do this.
So no, the trademark examiners will only offer a supplemental register or suggest applying for the supplemental register if they believe that your trademark doesn't meet the requirement for a principal register. So a strong trademark is something that is arbitrary or fanciful in nature. Of course, it doesn't always have to be arbitrary, like the classic example of Apple used in the context of computers. That's arbitrary, right? Apple has nothing to do with computers, or didn't used to before the trademark existed. So if your trademark isn't as strong, though, like, again, Joe's Coffee Shop, which you probably wouldn't be able to get approved anyway at this point. But if it's something like that, they might say, you know what, it's not unique enough, it's not strong enough for you to get the rights on the principal mark, but since you're already using it, you can get it on the supplemental mark. And then the other benefit is that if you show after 5 years of using that mark, you can then go back and apply to get on the principal registration later on. if you can show that it has acquired distinctiveness over this time.
Gotcha. Well, that makes more sense. Thanks for answering that for me and our watchers here. So is there anything else that we need to know about principal and supplemental? I mean, you covered a lot. So the goal is always to get on principal. And if you have to take supplemental, you take supplemental and you go back after 5 years.
Exactly.
Right. Awesome. So this has been another Google My Business Problems series recording. And you can see Erica's other recordings on the My Clone Solution blog. And you can contact Erica if you need her services. On the next slide, her contact information will be available. Thank you so much, everyone, for watching. And we'll see you on the next Google My Business Problems series.